Hello, everyone, and welcome to Immigration Talk Show. I'm your host, Nipasa, and I'm really happy to have you join us. And welcome once again to another very interesting and insightful webinar that's lined up for you on a very important discussion about H-1B. But before that, I've got this very important disclaimer, and that is by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use at your own risk. So, friends, once again, with that in mind, you can also participate in this session by calling us up and by commenting wherever you're watching. And for that, you need to call us on this number 425 436 6335, and the access code is 988 888. So, yes, without further ado, please help me welcome our guest for today, none other than attorney Justin Rivera from Wasden Immigration Litigation. Once again, hi, Justin. How are you doing today?
Hi, I'm good. Thank you for having me. Not as good as I ever am on a Friday, which is when I prefer to have these conversations. But I'm pretty good for a Tuesday.
Thank you so much for joining us. It's different, of course. The and plus, it's been hectic, I suppose, with H-1B, the changes, and tell me more, please. What's happening at Wasden Immigration Litigation?
Well, there's a lot going on. Things are constantly in, flow. Changes are basically coming every day as new policy memorandums get rolled out by the present administration. Today, we were actually just notified that I guess there will be an update to certain forms like the N400, the I-485, and a couple others, where people are going to have to include their social media handles. And the purpose of this, according to the memorandum, is to assess whether or not the individual is admissible to the United States, which, if you put two and two together, probably means your socials are now going to be getting reviewed. And if there's something in there that the officers reviewing the case doesn't like, it could lead to issues. So that's, one of the new things that we're dealing with now, in an ever-evolving, atmosphere for immigration. The other big change is, which just kind of happened fairly recently, is it looks like there will be a re-implementation of the notice to appear, the NTA, for denials for individuals that are placed out of status by virtue of the denial. If anyone was a part of immigration, U.S. immigration in the past, this was actually a tactic that the Trump administration had tried in 2018, I believe. They had basically tacked on NTAs, notice to appears, at the bottom of a denial, and in essence said, you're now in a removal, a deportation proceeding, and this is your notice to appear. The process didn't work because it wasn't really well thought out. The NTAs were often problematic. They failed to contain the necessary information to qualify as notice to an individual, and the policy just didn't work and it went away. The reintroduction of this policy, it's problematic for starters because it places legal people who have immigrated legally to the United States, undergone it, inspection and admission. It places them now in a category where they're supposed to be subjected to, removal, deportation, basically something that in the past wasn't really logical. The people who came to the country, who entered the U.S. and were inspected and admitted with proper documentation, and inevitably, eventually through the process, for whatever reason, ended up going out of status. There's always been leeway for those individuals. Now, yes, the individual's out of status, but for the most part, if they're able to find a way back into status, or they were allowed to travel out of the United States and then they could re-enter on a different visa, these were all kind of options. When you introduce the notice to appear, the NTA, it muddies the waters and creates a different process where you're basically putting people from, work style, business immigration visas, student visas, things like that, moves them into a bucket that traditionally they were not supposed to be in. And we're going to have to see how the process plays out. We'll see if there's, litigation or how these cases end up coming out as they proceed forward. But at the end of the day, it's not beneficial overall, I think, for immigration. I think it's very odd to think that the people that, the administration wants to target are people that are in the country legally, people who are obtaining degrees or have obtained degrees and are performing highly skilled positions with reputable organizations. So we'll see as that data starts to come in, because I haven't actually seen one of these NTAs. There's only been the policy on it, but we'll have to see it as it comes in and how it evolves and how it's utilized by the administration.
Right, Justin. Thank you so much for giving us a sneak peek into the latest updates on the H-1B program. And guess what? We have our first caller already. So I would like to say hello to him because he's been waiting ever since the show started. So, hi, Abhishek. And he had a question about H-1B. So, are you there online?
Oh, yes, I do.
Okay, Abhishek, go ahead. It's Justin Rivera. You can ask your question.
Hi, Justin. So I have an employer who is willing to sponsorship, but they say that I have to pay for the immigration, the fees and everything, but they are going to support the whole process, but they're not going to pay for the process. And how would I deal with this kind of situation?
So yeah, we had talked about this actually on the last call. You are not authorized to pay any fees that are associated with your H-1B petition. In fact, if USCIS or the consulate were able to procure that information at any point, they're probably going to levy a fraud or misrepresentation charge, because their assertion is that you did not qualify for the position independently. You paid for the position. So it's almost saying you paid to play in this process. It wasn't that the company came to you and said, we have a job for you, we want you to work in this position. It's more so a quid pro quo of, hey, we can sponsor an H-1B for you, but as a result of that sponsorship process, you're going to have to pay the fees. There have been individuals fairly recently that our office has actually been working with on their cases where that exact scenario occurred, and it played out horribly for that person. Now, I understand risk versus reward in situations where people say, oh, well, this is my only chance or my only opportunity. You do have to understand the risk of that. That is illegal. That is, in the eyes of USCIS, CBP, the consulate, it is not a permissible activity. And if any one of those entities catch you in performing that, you can end up with a permanent inadmissibility bar to the United States. So I would strongly recommend that you do not proceed with that course of action. You are not entitled to pay for the fees that are in relation to the filing of your H-1B petition, be they the filing fees or the fees for the attorney.
Okay. So the best I can do is I can just let a lawyer notify them, okay, this is what exactly happens, and make them familiar about the process. And it's up to them whether they want to do it or not.
Yeah, I would say this. I mean, the way that the H-1B lottery works is initially there's that $215 fee to even go into the lottery in the first place. So that's kind of the first hurdle in the process. If your case goes into the lottery and it's selected, there needs to be a very clear understanding that you're not the person paying the H-1B filing fees or the attorney fees. Those are not permissible fees for a beneficiary to be paid. That's why there is a petitioner. The petitioner in the H-1B is the party that's responsible for footing the bill, because what they get out of it is the worker. And that's the whole point of the H-1B program, is so that the petitioner can sponsor an individual to come back into the United States, or come to the United States initially to work for the organization.
All right. Thank you so much, Abhishek, for joining us on call. And I hope you've got your answer. Thank you, Justin, for taking that up. And there you go, Abhishek, our first caller. And you two friends can join us. The phone number is on the screen. Do join us on call. And hello to everyone out there who have commented with your questions. We will take them up. Just stay with us. So, without further ado, Justin, I also had prepared some questions, and you've already updated us about some of the key changes that happened very recently with the H-1B lottery process this year. And if you want to compare it to the previous years, what would you like to say? Any highlight that you want to point out?
So, I mean, yeah, there's a fee increase. Obviously, the fee for registration has gone up to $215 per individual for the registration. So you're putting, the employer has to put more skin in the game without a confirmation of a legitimate, selection, because it is a lottery. So Other than that, we are again seeing the beneficiary-centric lottery, which basically, based on everything we've seen from USCIS, this is how we're moving forward. They believe that this is the easiest way to combat the misuse of the lottery process, which was situations where 7 companies all petitioned for the same guy to give him 7 different spots at the lottery. That's no longer the case. You can't do that anymore. Your biographical passport identification information is going to go into the system one time, regardless of how many petitioners sponsor you. So if you have, like Google, Apple, and Infosys, all of them want to sponsor you for an H-1B, that's great. They'll put your information in. You do not get 3 cracks at the lottery. You get 1. And so that's how they've really stopped the multiple registration issue from becoming a problem. As a result of that, they haven't really had to codify the multiple registration issue. So it's not something they're looking into anymore. It is something they had looked at like they looked at that for registrations for the initial lotteries for people when they hadn't moved to the beneficiary-centric system. So that's the big, that's a change from last year. That's permanent. So the big thing's just the increase in fees. But, if you are selected, you're in a spot where you're kind of getting to pick your employer. So there is somewhat of a benefit to having multiple people register you. It just doesn't give you more opportunities.
Right. Beneficiary centric. And thank you so much, Justin, once again for highlighting those very important changes. So, folks out there, I'd like to say do not forget to subscribe to us. Our handle is Immigration Talk Show, and we are on YouTube, LinkedIn, Facebook, X, and also on Instagram. Thank you so much for joining us. Leave your comments, leave your questions in the comments. And also, Justin, my next question to you would be if you could tell us what about the eligibility requirements, for applicants participating in the 2025 H-1B lottery?
Yeah, so I mean, it's same as it has basically been. You need a bachelor's degree in a specific specialty or the equivalent of a U.S. bachelor's degree. For individuals studying outside of the U.S., you'll be able to show eligibility at the time of filing by getting an evaluation, a foreign degree evaluation, or if that's not going to get you where you need to be, it is possible to work on combining education with work experience. But for the most part, you're going to be an individual that's got the equivalent of a bachelor's degree, a U.S. bachelor's degree, and that gets you entered into the lottery. Those with U.S. master's degrees, they get sort of a 2-bite at the apple type thing because you have the normal lottery and then you have the master's cap, which is those additional 20,000 spaces. So yes, you are at an advantage if you have a master's degree, a U.S. master's degree, but just for basic eligibility issues, you just need that equivalence to a U.S. bachelor's degree. And so anyone with that degree is eligible to have their H-1B filed in the fall.
Thank you so much. And all the best to folks out there who are, trying their luck this time in the H-1B 2025 lottery. So moving on. So I just say hello to Film Moji, Harinath, and also Anusha. Thank you so much for joining us with your questions. And Justin, how does USCIS registration process work? And if you can also highlight the H-1B electronic registration process, which is very important, and what are the critical deadlines of the 2025 lottery?
So lottery opens March 7th. I think it's 11 a.m. Central, closes March 24th. That's your window for submission, and that's it. There is no leeway typically. Has there been leeway in the past? Sometimes when the system crashes, they will allow an extra couple days for registration, but I wouldn't bank on that. I know a lot of times when people do registration, they want to just get it out of the way, shoot it in and get it done as quickly as possible. My experience with the system has been, I try not to register anyone the first day because then you're racing with everyone else. The system's just going to be crashing repeatedly. I usually like to wait a day or two to start my registrations and then just knock them all out at the same time. The registration process itself is very simple. The petitioner they create a USCIS account. They either link that to an attorney they're working with or they proceed on their own. The registrations informations are filled in for the people that they're going to be representing in the lottery. You kick it back to the employer to confirm the information is correct. And then once that is done, you move forward with the actual lottery process, which will happen the first week of April. And that's when the actual selections begin to come in. And so that's where we figure out who's filing and what the window is for filing. And I know everybody's always asking, like, did my case get selected? Like, do we know? Have we got confirmation? You need to understand they trickle out the notices. They don't fire them all out the same day. So the way the lottery system works is it's run, results come out, and then results begin to incrementally come out over the next couple of days. USCIS will notify everyone when they have completed the lottery process. And so at that time, that's when everyone gets their filing window and people file cases and we see what gets approved, what gets denied, who doesn't file. And then after that process is usually where there's a determination about whether or not there's a second lottery.
Right. So, I mean, usually how long it is when USCIS tells that they're really done putting out all the results?
So usually it's going to be that first week of April. Once you get past that, typically, unless there's some sort of system glitch, that's when you're going to see results. That's when you'll actually get selection notices. The selection notices do go to the petitioners. As a beneficiary, you're not entitled to a selection notice. That you don't get some sort of cool ping from USCIS that says your case got picked. So it is dependent on the petitioner. That being said, it is my opinion that employees wait for the process to conclude before contacting your employer. Your employer is probably going through the same process with everyone else that they registered for. They would probably prefer, or their HR or their legal rep would prefer to send out one email to everyone that was selected rather than do it in these small batches to appease people who want to know whether or not they were selected. So I would just say, pay attention to USCIS's websites, their notifications, and see when the lottery is closed. After the lottery is closed, wait a day or two. If you still haven't heard anything, that's probably when you want to reach out and see if your case was selected or not.
Thank you so much, Justin, for taking that up. All right, so moving on, I have this next question, Justin. There are many new policies and also, proposed regulations that could impact the H-1B cab selection or approvals this year, right? So would you like to maybe highlight a few?
Yeah, so I think for the actual approvals, the BFJO, which is the acronym that we're all now using for bona fide job offer, that's going to come into play here for the first time in CAP. So what that basically means is USCIS has codified the notion that you must present a bona fide job offer at the time of filing to establish that the person will be performing a specialty occupation. What that means is if you are working in-house, you'll need to be able to present documentation as an employer that there is work available for the individual to perform. If you are working off-site, say at a third-party location for an end client, you'll likely need to produce documentation that there is a need for the individual. So that need will be, contracts, work orders, vendor letters, client letters. Furthermore, if you are working at an in-client site, USCIS has now created a test, basically a system, to determine whether or not it's the end client or the petitioner who is the one that can make the determination as to whether or not the position qualifies as a specialty occupation. In the event where the end client is the entity who is deemed the one responsible for this, my assumption is you're going to need to get some sort of client letter or documentation that pretty explicitly states what the position requirements are. That test, in my opinion, is going to be completely bastardized by USCIS. I don't have faith that their officers are competent enough to make a determination as to whether or not someone is coming in to fill a temporary position or is filling a full-time position where they are a member of the organization chart of the company. The officers have never done this before, and they don't know what they're doing. There will be problems with adjudications as a result of that. So all that being said, I think those are going to be the biggest issues to highlight for this year. the idea that you can file, like let's say you want to bring someone in and be a software engineer, but you don't actually have something for them to do, like a project to put them on. And your thought process is, I'll file the H-1B in the lottery, and then by the time we get to October 1st, I'll find a project to put them on. That's going to be really difficult. I think unless you're in a situation where your petition just kind of gets through and gets approved without issue, you're probably looking at a request for evidence that asks for that specific examples of the bona fide job offer. So as a result of that, I think that those changes are probably going to, I think those changes are probably going to result in an uptick in denials this year until employers get used to the process. There is obviously litigation on that could come into play, but whether or not that litigation is finalized at this point or a decision has been made, we don't know. So for now, this is the world that we have to exist in. So I think those are going to be the big issues. Will be the specialty occupation at a third-party client site and the bona fide job offer.
Right, Justin. And when you talk about specialty occupation and the job description, how lengthy or how descriptive should it be?
Well, I mean, I think you're going to have to be savvy enough to make, create this nexus between what the individual is going to be doing and the duties that they're going to be performing. I think that the days of just kind of copy pasting the ONET job duties for a software developer are over. I don't think that that's getting you over the hurdle of an approval. I think you're going to need to tie in and justify, what it is this person's doing and link that into why a degree is required. And I think that that's going to be more difficult this year than it has been in the past couple of years, just because we're looking at a different administration. I also think that in terms of individuals that are on F1 status and they get selected and they're going to change status, I think we're going to see very stringent interpretations of OPT and STEM OPT unemployment, as well as, proper eligibility for OPT or CPT. I've said it a couple times before, but I will reiterate it here. We have definitely seen cases where people are getting basically popped for performing unpaid OPT. And unpaid OPT is permissible. It's STEM OPT where you have to be paid by your employer. However, USCIS is starting to take a stance where they basically say, our opinion is that this OPT unpaid position should have been paid. It's a very weird argument that shouldn't really hold muster, but it's something that's going to have to be pushed back against, because it's yet another arrow in their quiver for a reason that they could deny a change of status. So I think that those are going to be issues too. And then, things like schools, where the person went to school. I think obviously the day one CPT schools are targeted at a higher rate for RFEs than other universities. So I think that'll come into play as well.
Right, and also thank you so much, Justin, by the way, for taking that up as well. And I think we should quickly take a couple of questions from the audience, not to keep them waiting for too long. Let's take up Anusha saying, I heard that USCIS might be implementing changes in the lottery process this year. Yes, we have been discussing. Anusha, I hope that you have been tuned in ever since the beginning of the show. And is there anything different about 2025 H-1B lottery compared to previous years? Okay, we've taken this. Also, I would like to know, once my H-1B is approved, am I required to work with the same employer, or can I switch employers before my visa is stamped?
So here's how it works. In order to be qualified, in order to count against the H-1B cap, you must perform one of two activities. You must be physically present in the United States after October 1st, unless you've changed your start date, but the typical start date is October 1st. You must be present in the U.S. for 1 day to have worked with that employer on H-1B, or you must have received an H-1B visa stamp at the consulate abroad for employment with that employer. Now, there's two things to remember in regards to the visa stamp at the consulate. One, when you go for that visa stamp at the consulate, there must still be a job offer for you, a legitimate job offer that exists with the organization. If there is not a job offer that exists and you attend your visa interview making that assertion, That is a material misrepresentation, which can either be caught at the consulate or by CBP when you enter the United States. I'll give you an example of a case where this exact situation played itself out. We had a client who came to us after all of this happened, but they basically got their H-1B visa stamp abroad with employer A. And after they got their stamp, the employer said, we don't have a project for you right now, but why don't you just come into the United States? And once you're here in the US, we'll find something for you. So the employee said, I'm not doing that because that doesn't show that I have actual work or an actual project. So instead, he said, well, I'm going to find a new employer. I'm going to transfer my H-1B to that employer, file an H-1B consular process not subject to the cap. So he did that and got his H-1B approved. He was counted as cap exempt because he had that H-1B visa stamp that he was able to include in his petition. However, when he entered the United States for the first time, the employer, the CBP officer said, hey, why do you have another employer listed on here? And he explained, how this happened and why he's in a different employer. Totally permissible, okay? That is valid. It is okay to do that. He leaves the U.S. and travels back in a second time. When he traveled in the second time, he was taken to secondary inspection, where they basically went through all of his documents and information and came to the conclusion that he never had a bona fide job with the employer. So basically saying his original H-1B employer, who he went for stamping with, there was not a job available there, and he never actually had real work, even when he applied for the visa stamp. His visa gets canceled, and he gets subjected to expedited removal. So all of that is to say, there are two permissible avenues: work one day on H-1B here, one day, work one day on H-1B with the employer, so you're counted against the cap, or get that visa stamp abroad. But you need to be very careful with getting a visa stamp for an employer and then coming into the U.S. with a different employer without ever having worked in H-1B status for the initial sponsoring employer, because you're going to have to be able to very clearly explain your timeline and thought process that led you to the conclusion that you needed to come in with a different employer. So that may have been an over answer to your question, but that's the answer.
Thank you so much for taking that up, and thank you, Anusha. Moving on to Harinath. Hi, greetings of the day. Hi, Harinath. Thank you so much for joining us. Tell us where you're from. And Harinath is saying, actually, my H-1B applied from my current company and petition got approved last year, 2024. Actually, my qualification is BSc Computer Science with 14 years of experience in IT professional. Could you please suggest on the same?
I'm a little confused as to what we're suggesting. You have an approved H-1B and you seem to have the qualifications that fall within the parameters of the H-1B from an employment standpoint. If you're working in IT with a computer science degree, that's pretty dead on. The only issue would be, I guess, if the degree was not the equivalent of a 4-year degree from a U.S. institution. And if that was the case, then you would be looking at having to kind of utilize your 14 years of work experience to correlate it to show progressively responsible experience within the field, getting like a sort of combo evaluation. But with a bachelor's of science in computer science, I think you should probably be fine. But even if not, you would need to go that eval route. Now, I would say this for the combo evals. I think for the combo evals, we're going to have to be a little cautious about what the letters look like, how detailed those letters are from former employers. I think that simply just saying, this person was a data analyst from X to Y, and they did these 2 or 3 job duties, I think that's not going to really pass muster for showing progressively responsible work experience. So I think what we're going to really all want to work on is kind of getting more robust information from those former employers that talks about, what were the technologies that were utilized? Were you ever promoted? Did you ever take on more responsibility than you had when you were hired? How did you do that? All of that, because what USCIS is going to do is they're going to find ways that they can deny cases this year that they wouldn't have done in the past. One thing that they try to look at is obviously specialty occupation. The other thing that they're supposed to look at is beneficiary qualifications. When you get into the beneficiary qualification side of it and you're having to do those combo evals, they will often attempt to attack the validity of the professor's credentials that rendered that eval, and they will go after the letters. So if you're able to kind of head them off, and like, for example, you have 14 years of experience, let's say that 14 years of experience is spread out between two companies. You would need two letters, and I would say each of those letters probably need to be, at least 2 pages long, if not 2.5 to 3 pages long. That provides that really robust explanation. And for example, if you were with one company for 10 years, it's very unlikely you held the same role the whole 10 years. So I would say we need to talk about what was the role you held initially, what was the role you were promoted to, what was the technologies that you were using, were you ever, training other individuals, were you ever working with other individuals who held degrees in a similar specific specialty. I think all of that stuff is relevant. In regards of like the professor's qualifications, there's not a lot you can do about that. I mean, the evals that come from the professors usually contain information that explains how the professor is eligible to make the decision. So all you can control is the variables that you have on your side. So yeah, that would be my thing, is if you need that combo eval, we're going to have to get into way more specific detail. And it sucks, to be blunt, because it's sometimes hard to get an employer that you haven't worked with in 6 years to put effort into getting you a letter so that you can be, sponsored for an H-1B with a completely different organization. So I understand that that's a problem, and hopefully you've maintained that relationship with the company. Hopefully that was a good answer to your question.
Yes, it was. Thank you so much, Justin, for taking that up. And Harinath, thank you for joining us. Next one is Filmy Moji asking, I got my H-1B stamped in January 2023 and it was valid till September 2025. Um, I didn't travel to the USA because of personal reasons. Now the employer cancelled my H-1B petition last month. Do I come into cap exempt or I go for the lottery again? Please advise.
So yeah, kind of the same way that I talked about earlier. If you have a visa stamp, if you received a stamp, and at the time that you interviewed, there was a legitimate position available for you with the organization, then the opinion of the service is that you have been counted. Now, that comes with its own set of hurdles and issues that we highlighted previously. If you've never come in and worked a day on H-1B for that company, there is an inherent suspicion that exists with Custom and Border Patrol that you did not actually have that job available when you went for your interview because you never came in. So hypothetically, if you were to file for a new H-1B cap exempt using that visa stamp to show eligibility, USCIS is likely to approve that petition. Now, I think after that point, it would behoove you to go ahead and just apply for another H-1B visa rather than trying to enter the U.S. on a previous visa unless the visa is no longer valid. But I think it would probably be in your interest to go ahead and do that. If you do have a validity period left, time left on that previous visa, be prepared to face scrutiny when you come in, because they're going to see that mismatch, and it's probably going to lead to questions from them. But yeah, I mean, yes, you're eligible, but with the caveats that USCIS is probably going to be okay with you. The consulate is likely to be okay with you. Be prepared for CBP to provide a higher level of scrutiny.
Thank you so much, Justin. And Filmy Moji, thank you for joining us. I hope you've gotten your answer. Meanwhile, Anusha says, thanks a lot for making this very clear for me. Thank you, Anusha. We'll take up Priya Patel, but after some time. Justin, now though, if you could tell us, what strategies can employers and applicants use to maximize their chances of being selected in the lottery?
I mean, for the selection process, it's beneficiary centric. Like I said, there's not really a whole lot you can do. The lottery isn't like, there's no explanation, clear cut explanation about the lottery where they say if you register early, you have a higher probability. That's just not true. The fact of the matter is they put everybody in the same pot, and everyone's subjected to the same odds essentially. So there's not a lot you can do there. The only real benefit, if you have multiple registrations, is just that you're able to choose which employer you would like to work with when it's time to file your H-1B.
Okay, thank you for taking that up. And now I got another question, and this is with regard to the beneficiary centric. Of course, how does the lottery system actually handle the multiple registration by the same employer for a single beneficiary?
So the way it works is if that person is selected, each employer that sponsored them basically gets a notification that the individual has been selected.
Mhm.
So the individual then has the opportunity to decide which employer they're going to go to. Um, and that's really it. That's the only benefit. Years ago, if you had five people sponsor you, you had five chances to get selected. But that's no longer the case. Because of that beneficiary centric change, you only have one opportunity, regardless of how many times you're entered.
Okay. Thank you so much for taking that up, Justin. And now I got another question, but I think before we take up more questions, we should quickly go for a short break. And folks out there who want to contact Attorney Justin Rivera can call him up also on his number and can go visit www.wasden.law. And you can call Justin Rivera at 844-592-7336. But I think it's best to email him with your queries, and his email address is support@wasden.law. And me as well, you can email me at nipa@staffingme.com, or you can leave me a WhatsApp message or call me on my number 408-335-6444. But don't go anywhere, we'll just go for a short break and be right back here on Immigration Talk Show. Hello and welcome back, everyone, to Immigration Talk Show. On the second segment on this very interesting webinar we're having today with none other than Attorney Justin Rivera on H-1B Lottery 2025 and what you need to know. So, thank you so much, folks, for joining us with your questions and on call. And if more of you want to join us on call and ask the questions to Attorney Justin Rivera yourself, you can call us on this number 425-436-6335, and the access code is 988-888. But definitely, folks out there, don't forget to subscribe to us. Our handle is at Immigration Talk Show, and hit that bell icon so that whenever we have discussions like these, you are notified. And with that said, Anusha, thank you for joining us, and also Harinath and Filmi Moji and Priya Patel. We will take up your question very soon. So, welcome back, Justin. I hope that you are enjoying the session and are ready for more questions with us.
Yeah, sure thing.
So, Control, if you can display the next question on the screen, please. If we can take some of the questions from our Facebook group, will be great. So, this is from Navya. Hello, I got laid off in March 2023 and I moved my visa to a consulting company, but the H-1B transfer did not get approved for a year. So I got approved on July 2024. The thing is, I worked on H-1B receipt notice for a year. I'm just fearful that when I go for stamping, will it become a problem that I worked on receipt notice for a year? Thanks for your help.
No, because you can work on that receipt notice for up to 240 days as long as it's timely filed. So as long as you were, let's say you were laid off March 2023 and you had an H-1B that was approved till September 30th of 2023, as long as you filed that H-1B within the 60-day grace period, even if you didn't at this point, because USCIS has approved the petition with an I-94. But let's say hypothetically you did get that, filing done within the grace period, you're allowed to work. Well, I guess you're allowed to work up to 240 days. So now that I think about it, you're saying a year.
A
So I guess
year.
that's actually over 365 days. So yes, now that I'm doing basic math in my head, that could be problematic in the event that you did work beyond that 240-day threshold.
Mhm.
So I'm not great at math, but if you're over 240 before the approval, then yeah, maybe you see an issue at the consulate if you continued working once you went over the 240-day threshold. I think in that circumstance, you're just going to have to be upfront at the consulate and explain, my employer had me working for the company. I thought I was working, in valid H-1B status, subject to the terms and conditions of my H-1B. I stayed with the employer. I worked in the area of intended employment. I was performing the job duties I was supposed to be performing. Is the consulate going to be knowledgeable enough to kind of go after you for that? I'm not really sure. I genuinely don't know. I don't know if the officers are savvy enough to look at filing dates and approval dates. I would definitely say that you don't want to like make a misrepresentation. You don't want to say something that's not true. So if you did work past that 240 day, um, you know, willing to explain what happened, they're way more forgiving when you explain that you inadvertently violated status, as opposed to making a misrepresentation and saying that you didn't. So
Mhm.
yeah, I don't know your exact case facts, but if you want to send me an email, that's fine. We can kind of work through the numbers and see if there's a possible violation issue. And then, part of what our firm tries to do too with people going for visa interviews is getting them prepped for the interview, especially when they have status problems, doing the DS-160 properly so that they have the answers in there that are properly reflecting what has occurred. And that might be a service that might be needed by you. But I would say to you, and I would say to anybody as a general point, if there's a violation of status issue or even the inclination of a violation of status issue, I have always found it much better to just admit the violation of status to be on the safe side and say, this happened or that happened. It was a mistake. I think that's always much better than the opposite, which is to just brush it under the rug and not say anything. When you don't
Mhm.
say anything, you open the door for fraud or misrepresentation. I cannot put forth to you guys enough. Fraud or misrepresentation is a permanent inadmissibility ban from the United States. So unless you're able to procure a waiver, which I got to tell you guys, in the era of Trump, good luck getting a waiver. But unless you're able to get a waiver, there are very, very limited avenues for you to get that fraud finding removed. So that would be my point for you, Navia.
Thank you so much, Justin, for taking that up. And better play safe than be sorry later. So, yes, don't leave any space for fraud or misrepresentation. Thank you, Justin, for taking that up. And Navya, all the very best. Folks, don't forget to check out Wasden Immigration Litigation also on LinkedIn. And my next question is on the screen, Justin. This is from Zachary asking, hello, what requirements must a company meet to submit a perm application? For example, how much should be in the company's account and how many employees should it have?
There's no threshold. Okay, perm is a fickle mistress, and it's really just dependent on how well your company prepares the labor certification. So yeah, there's no floor, but as a general thought, if you're a very, very small company, are you likely to receive a higher level of scrutiny? Probably, especially in modern day. But the way that perm works is you're doing the labor certification process. After the labor certification process, you're getting into the recruitment period where you're having to deal with the job postings and all of that, which all of that has to be done properly. And then once you get through all of that process and everything's done and closes, then you usually get to the final step of the process. And then you're onward to the I-140. But as a general thing, like the best advice I can give anyone for perm is don't do it by yourself. You need to work with an attorney. The reason why is like, I understand that there still exists people out there who think that they can file H-1Bs on their own without a problem, and I get that. An H-1B is it's a much more immediate process unless you file in regular processing. But usually 15 days to an RFE, you get a decision, approval or denial, you know where you're at. Perm's much longer. It takes a lot longer to get through. And if you mess up some part of that process and it puts you in a position where there's a denial, whether it's at the I-140 stage or the perm stage because someone's made a mistake, you have lost a significant amount of time. Most of the time, perm is something that people press to be started around the third year, maybe after the initial H-1B extension. Companies can drag their feet, though, and not start it until the fifth year or even the back of the fourth year. And then you're getting into the problem of whether or not you're running into a 6-year max out or whether or not you're eligible for that 1-year extension based on whether the perm was filed 365 days before the expiration of status. All of that stuff is to say your smartest option is to just work with an attorney early, make sure that they're taking care of the case for you, and that way you have that peace of mind and that higher probability of success, because it is a difficult process. And I've seen people come to our firm that have basically tried to do perm on their own and ended up getting caught at the I-140 stage. Basically, I think I can give an actual practical example of where we had a case that came to us where basically the company said that you needed X amount of time experience for the position, and that this person qualified because they had X amount of experience for the position. Well, when they filed the I-140, they provided a letter from the company that explained that the guy had worked with the company for X amount of time. But in the letter, they said that the guy only worked part-time. Well, part-time and full-time are counted differently for the process of making a determination of whether or not somebody holds the requisite amount of experience for a position at the I-140 filing stage. That ended up putting them in a position where they're having to respond to a notice of intent to revoke to clarify the information that they've already provided. That's the kind of thing where hopefully if you're working with counsel, you don't run into that because they've already addressed that issue at the outset.
All right. Thank you so much, Justin, for taking that up. And now, moving on to our next question, Control, if you can have it on the screen. This is from an anonymous member. I'm still waiting for the approval of my perm application, which we submitted in October 2023. Are there any other members of this? Okay. What should this person do, Justin? Any idea about his perm? How long does it take anyway, approximately?
That's a long time. I mean, I'm used to seeing 6 to 8 months. So yeah, I think that's not ideal. That's a peculiar situation. I would say, do you know whether or not your employer got audited? Because if your employer was audited, then that could be the reason for the delay. So yeah, I would look into that because that's too long. That doesn't really make sense through a normal process. So it seems like you must have been in a situation where your company got audited, which can happen. There are random audits and then there's targeted audits. So even if your company does everything right, there is still a probability that you could be audited.
Okay. Thank you, Justin, for taking that up. This next one is Hello, all. I have a question. I confirmed that I need to switch my Dropbox appointment to an in person interview for my H-1B visa stamping. After canceling my Dropbox appointment, I started rescheduling and noticed I had one free reschedule, so I didn't have to pay any visa fees. However, I was prompted a delta amount of rupees 615 due to a change in dollar value in terms of Indian rupee. So I selected one of the available payment options, but it was immediately redirected to the OFC. It's incomplete, but do you figure out the whole question, Justin?
I'm so sorry. I'm lost. I'm trying to
So,
understand what he's asking.
so I think this person. All right, let's ignore as the control says. Let's move on to the next one since
Um,
the question.
so I will say generally, I think that's interesting that you were told to reschedule the appointment online. For people that had their Dropbox appointments canceled, especially those who had it canceled because they no longer fell under the policy change, which is where they went from 48 months to 12 months. Most of those individuals have received a notice that they can walk in for a visa appointment. I think it's like Monday, Tuesday, Thursday, Friday between a certain time, and so that's what I've seen. So I think that that's weird that you're kind of independently doing this on your own for the process. Maybe things have changed since then, but initially what I saw was you get a notice that said like, you no longer qualify. You can come in for an appointment, but you have to come in for an appointment after March 5th, and it needs to be on Monday, Tuesday, Thursday, or Friday. So that's what I've seen. So this is a little bit outside of the norm for me.
Interesting it is though, because of the value of the currency also. Anyway, thank you for taking this up, Justin. Let's move on to our next one. This is hi all. My present company A will be applying for my H-1B this March. Meanwhile, I have given an interview for company B and waiting for result. A has told if they apply, I have to work for them next 6 months at least. I want to work for B as it is much bigger company and better pay. Now, how do I hold A from applying till I get the update from B? Is there any document or signature I have to put before they submit my application?
No, not for an H-1B. H-1Bs, everything is done by the petitioner. They're the entity responsible for, filing. They're the entity responsible for registration. So, um, not really anything you can do in terms of a holding pattern. I think what we're kind of missing in this process is whether or not this is a cap H-1B, meaning that they're applying for you in the lottery, um, or this is a situation where you're trying to transfer from a current employer. If it's a lottery, then I would just say if both companies want to sponsor you, let them do it. Remember, it's beneficiary centric. So if you're picked, you're picked, and you get to decide which employer you're going to want to move to. Now, the the registration is not in and of itself confirmation that you're going to work with that employer. There's nothing from your side for registration that you have to put forth that says I will work with this employer if they file my registration. So I would just say you could play the long game and just wait and see which case gets selected in the lottery. I would also say this: the way that they structure the requirement for you to work with the company for at least 6 months. I mean, that's up for debate in terms of analysis. That's an employment law thing, depending on the state where you're going to be working, whether or not that is an enforceable agreement. There are some companies that like to put in what are called clawbacks, which is basically saying, you need to work with our company for this amount of time. And if you don't, we're entitled to money, and the money is for training you, for having to reassign someone to the client if you leave or something like that. The enforceability of that really depends on the state law, but what it cannot say is an explicit statement that the money being recouped is money for the H-1B. Like, there's no way to backdoor in that statement. So if you sign an employment agreement that says if you don't work with the employer for more than 2 years, the employer can come back for H-1B filing fees and all that, that's not enforceable. You can't do that. So I would look into the validity of that as well. But generally, if they're both going to, sponsor you in the lottery, great. If not, you need to just move forward with it.
Okay. Thank you for taking that up, Justin. Those were some of our questions from Facebook. But before we leave, Justin, I have one more question. And if you could give out an advice, or two, if you have for the first time applicants and employers who are navigating this H-1B process this year.
Um, Sorry, that's my wife calling me again. I would say, just generally speaking, this year, I think that there is going to be more so than any other year a real desire from USCIS to produce evidence of fraud. There has been a lot of statements put forth, not only by representatives within the administration, but also with statements within the policy memorandum in regard to FDNS's site visits being made mandatory, that there is like this rampant fraud that exists within the H-1B program, primarily for third-party placement consulting companies. So I think that the level of scrutiny for third-party placement is going to be hiked up to a point that it has not been in the past. So I would just say be prepared for that. If you're not able to supply the documentation at the level that USCIS is going to want, you're going to have to work to produce alternative evidence with your representation. But ultimately, the denial rate, I think it's going to go up. There's no way, in my opinion, that we go through this year without seeing a spike in the denial rate for the H-1B cap. What that rate will be, we won't know till the numbers come in. But I definitely think there'll be more denials, and there's going to be a lot more fraud accusations.
Very interesting. Thank you so much, Justin, for today's very interesting webinar. And do you have more time? Let me just ask you if we have.
I really don't. My wife has called me like 3 times during this, so I really have to go.
Not a
Um,
problem. But thank you so much, Justin, for joining us today. And I'm looking forward that you can join us in the coming weeks as well. So, with that
mhm.
said, I'll allow you to go for now. But thank you so much. It was such a great session, very insightful. And yeah, let's get busy again since it is the middle of the week almost and we still got more days to work.
Yeah. Thank you guys for your time. I'll speak to you again soon. Bye.
Thank you, Justin. And folks out there, you can contact attorney Justin Rivera, and you can do so by calling him up on his number, and his number is 844-592-7336. And you can also email Justin, leave an email address with your case and your queries, support@wasden.law, and go visit www.wasden.law to get to know more about attorney Justin Rivera and, of course, Wasden Immigration Litigation. Also, check them out on LinkedIn and check us out as well. We are Immigration Talk Show. Our handle is at Immigration Talk Show. We are on YouTube, LinkedIn, Facebook, X, Instagram. Check us out, connect with us, follow us, and subscribe to us. Hit that bell icon, folks, so that whenever we have discussions which are so interesting and informative like these, you are notified and that you can join us. So thank you once again, and sorry, folks, for those of your questions we couldn't take up, but do stay tuned because we will love to, get a response for you. So thank you once again, everyone, for joining us. And this is Nipasa saying bye for now. But of course, we will be going live on LinkedIn, Facebook, and on X in the coming days. Also, every day from Monday to Friday, we come up with daily immigration dose. So do check us out and stay tuned on Immigration Talk Show. Thank you for joining us.